Continue.
List number 2, serial number 30.
Uh. Mm. Let me complete this list, RPFC. I'll take up that. Huh? Yes. Yes.
Serial number 13, Srinivas AR for petitioner Shauri HR.
You appear for the respondent. Morning they were asking for time. Yes, give some date in October.
Serial number 14, Prasanna VR. Shreya Kerala.
Yes, this also. Give some date in the month.
October.
Yes, 15 date in the month.
October.
Yes, 15.
Serial number 15. Serial number 15,
What happened to the mediation?
Srinivasan.
Failed? Use the phone or the
I have filed for enhancement, my lord. That may be connected with that.
You also filed?
Yes,
Where
ma'am.
is that?
It was on 8/9.
Huh?
8/9/25.
8/9?
25, yes, ma'am.
Take that list along with that. After in the
59
month
of 2000.
in the month of October.
Cheating.
Yes, next 16.
Serial number
And
16.
I'm furnishing copy, my lord.
It is submitted to the land council as the copy also to the council appearing to the respondent. Yes. Yes, 16.
16, for appellants. Hemant Kumar.
From 8,000 was awarded for maintenance. On 12/5/23, marriage was solemnized, and 14/8, within 3 months, she left the matrimonial home. And on 26/09/23, under MC 64/2024, we have sent a notice for restitution of conjugal rights. Contrary, she earns 15 to
The
20,000.
admission available on record would go to show that the respondent is working in the bakery of his brother-in-law.
Brother-in-law, that's not my big. It's a part-time. I work part-time there.
How many works you will?
No,
Then
it
might we
depends
have to
upon
take-
if I don't have a job. Like in Puli, we don't get every single day independent contractor. So a part-time job I do on weekends, or if I don't have any other.
March 2025, whereby the court had granted maintenance of an amount of rupees 8,000 to the wife. The husband is before this court. No notice is served on the respondent. No wakalat is filed on her behalf. The claim, the petition is filed on a 125 CRPC, seeking maintenance of an amount of rupees 25,000. It is a contention of the wife that the husband is having landed properties and is working and is earning. He is having income from from several resources. There are several resources, and he is earning considerable income, and it's a duty of the husband to maintain the wife. It is a case of the husband that is working as a daily wage worker, and whenever there is no and on and off, he is working working in his brother-in-law's farm, brother-in-law's bakery, and according to him, his income is per month. There is no material to show what is the income of the husband. However, doing the guesswork, court has granted an amount of rupees 8,000 as income. Then council submits the granting an amount of rupees 8,000 as income when 8,000 as maintenance when his income is 9,000 is on higher side. Next paragraph. When the notice is served on the the respondent has chosen not to appear before this court. The next paragraph. Having heard the counsel of the petitioner, peruse the material on record, even assuming under the facts and circumstances, peruse the material on record, even assuming under the facts and circumstances, considering it is stated that he is earning 9,000, he is working as a daily wage laborer and also earning an amount and also working in the bakery belonging to the brother-in-law. In these circumstances, this court deems it appropriate to modify the order passed by the so and so, reducing the maintenance amount from 8,000 to 5,000. Accordingly, this was dropped. Yes, next.
Question number 17. Number 17. Siddharth Suman.
Answer for a petitioner, my lords.
Yes, what is the order impugned?
Was the 125 of CRPC judgment that was passed, my
How
lords.
much amount is awarded?
30,000, my lords, per month. My lords, I am already paying these
Come
matters
to the
at page
operative
number
portion.
88, my lords.
What is the amount?
The respondent is directed to pay monthly maintenance of 30,000 each to petitioner number 2 and 3. They are the children of
30,000 each means
so
60,000.
Please, ma'am.
And litigation expenses of 25,000.
Please, ma'am.
What is attending on each adjournment? Attending on each adjournment
Try
dates,
to portray
traveling
by
in flight.
I try to portray by showing that I get my advocate from Bombay every time to show that I have enough. My lords, I am not saying that I won't maintain. From the MFA order of this honorable court, I am paying 25,000 as
How much you're
maintenance,
paying?
and I'm also taking care of the educational expenses, my lords.
25,000 as per the order in MFA
Please, ma'am.
per month to the wife.
Please, my lords.
And
And the education expenses of both my
how
children.
much? How much would be the
Because
education?
the education expenses till 2024, I've paid around I paid around 13 lakh for 13 lakhs 98,196, my lords, till the year 2023-2024, my lords.
How much it is per annum?
Per annum, my lords, I'll have to get the documents, my lords, because those documents are not placed on record.
So we'll do like this. You will continue to pay educational
I am,
and
my lords.
medical expenses of both the children, number one.
Yes.
Then number two, you are already paying 20,000.
25, my lords.
25,000 you are paying. So pay 35,000 per month.
Lords, if I may draw
It
my lords'
is
attention
it is quoted granted 60,000.
please, my lords.
So you pay 30,000 till the entire appearance. Then we will see once they come, once they appear.
Lords, if I may draw my lord's attention to page number 74, it is not that the petitioner number 1, the respondent does not have any source of income. She is also earning equally my business. The inference drawn is with respect to the loan that I've taken, my lords.
What is wife doing?
Wife, my lords, may kindly see she's page number 75, my lords. If I may just read out few points.
70?
75, my lords. The second line, we've confronted certain photographs during the cross, my lords, of Rajasthan in heart of Bangalore dinner with Bestie, with Vishaka Goenka Sangria at Kesaria, my lords. My lords, you may see at the end of the page, my lords. She has admitted that from April 2017, sorry, I apologize, my lords. My lords, may see para number 19, my lords. During the course of the cross-examination of PW1 recorded on 6/5/2022 in question and answer format, she shows her ignorance for specific question on 1/6/2017. 75,000 was credited to her account.
The land counsel appearing for the petitioner submits that the court without concerning any of the aspects that already in MFA as per the orders passed in MFA, an amount of rupees 25,000 is already paid by the husband, and court had granted now 60,000 in this case. It is submitted.
Cell number 18.
I pray for some time.
Yes, this is in the month of December. Yes, 19.
Cell number 19.
I didn't.
Lakshmikant K.
Malachi, when this matter parties have been settled, Malachi, they are filed.
The dispute is settled.
Yes, Malachi. The husband has paid 50 lakhs
Which
of
case?
Cell number 18.
TL number 18.
18.
Then why do you want time?
List
I
to-
asked. No. ಯಾವ್ದು ಮಾಡ್ತೀರಾ?
List to 18.
ಯಾವ್ದು?
Latif B for petitioner.
Sorry, I'm sorry. 18 is hard. It
18.
is private.
That is maybe list 1. This is list 2 actually.
List 2.
List 2.
List 2 is percent. 170.
No, Latif the number.
What is called is RPFC 109 of
109 by
2020.
20.
I'm
That
sorry.
is our matter, Malachi.
Dispute is settled between the parties.
Between they have filed the joint memorable action. They have
Where
filed
is that?
They have filed the memorable action on 14 July 2025. Page number 28.
Page number
28, Malachi. Para 8.
before the court. Yes. Then comes for the petitioner. Submits that the dispute between the parties is already settled, and on 27/7/2023 they filed a joint memo before the principal judge, before the third additional judge family court at Mysore, and a copy of the memo is filed before the court. Considering the joint memo dated 27/7/2023, the nothing's this in the light of the same, these writ petitions or the nothing survives for consideration in this petition, accordingly dismissed. Next.
Cell number.
Calculation, if we see, it is more than 10 lakhs 30,000.
No, it does.
And
as per-
moreover, as per the order dated 21/1/2025, they were supposed to serve a copy on me. They have not even done that. In spite of that, there was a conditional order on 25/2/2025. Unless the arrears are paid, within 2 weeks, the interim order stands cancelled is what the order, the conditional order that was made. In spite of that, they have not paid any amount to the respondents made. In spite of that, they have not paid any amount to the respondents.
On 25/2/2025, an order is passed. If the amount is not deposited by the petitioner within the time as sought for, the order of stay stands vacated automatically, and the respondent shall recover the amount in recovery proceedings. Then counsel for the respondent submits that in spite of an order, no amount is paid. Hence, the order dated 21/1/2025 stands vacated, and the respondent is at liberty to execute the order.
Execution order is already filed, my lord. Hearing this petition will not suffice because there is already an execution petition filed. Even there, they are avoiding payments.
No, I've recently paid 50.
Based on this particular petition, they come before the trial court and say there is this.
No, I have clarified it.
Please, please.
Cell number
Yes.
Much
20 urgent. 21.
But C.R. Ravishankar wants time. C.R. Ravishankar wants time, madam. C.R. Ravishankar wants time to file objection. 835 days.
What objections?
Delay of
855 days.
850.
Yes. At the request, yes. At the request of counsel appearing for the insurance company.
I will inform you.
20,
They have sent
22
a message,
MFA.
that's why. Yeah.
Yes.
Cell number 8. Prakash MH. HR Renuka.
Yes, Renuka.
Probably she has not reached.
Please.
What has happened is, the claimant's appeal has been announced by the Sango court
Give that file.
without connecting the appeal filed by the KSRTC. Here, my lord, they are challenging the negligence aspect. Here, my lord, they are challenging the negligence aspect. That negligence aspect may be noticed, my lord, whatever the enhancement made by the Sango court earlier, that may be
It can be
followed.
confirmed. Where is that part? There are two appeals before this court. One is MFA 1158 of 2020, which is filed by the claimant seeking enhancement of the compensation. Then 8 point MFA 3974 of 2021, filed by the KSRTC. A coordinate bench of this court, by order dated 29/10/2022, has allowed the claimant's appeal and enhanced the compensation, including the
Negligence, sir.
negligence on the part of the claimant. Then by order dated 9/11/2022, the order dated 29/10/2022 is recalled and directed the matter to relist along with MFA number 3974 of 2021. Give the file. He said is here. Land counsel appearing for the RTC submits that appeal of RTC. It is submitted that MACT has held that the driver of the bus is solely responsible for the accident. The accident is a head-on collision. The width of the road near the place of accident is 15 feet. Even as per the claimant, there is 2 feet mud road on either side of the road. Therefore, there was sufficient space for the vehicle which were moving on opposite directions. The corporation examined the driver of the bus and produced the photographs in support of the statement. The evidence and the documents produced by the corporation has not been properly appreciated by the MACT. It is submitted that MACT has accepted the interested version of the claimants to hold that the driver of the bus was solely responsible for the accident. And mere filing of the charge sheet against the driver of the bus itself cannot be a ground for the court to come to the conclusion that there is granted the compensation. Next, having further counsels on either side. There is a material on record. The submission, admittedly, the police, after a full-fledged investigation, has filed the charge sheet. And it is a charge sheet against the driver of the KSRTC bus. The evidence on record clearly shows that there is negligence on the part of the driver of the KSRTC. The submission that as it is a head-on collision and there is a sufficient, there is a 2 feet mud road on either side of the road, there is a contributory negligence on the part of the claimant. The said contention this court is not able to appreciate. In those circumstances, this court do not find any reasons to the circumstances. This court do not find any reasons to interfere with the finding of the court with regard to the negligence on the part of the driver of the KSRTC bus. When once the issue is dealt with by the court and there is that the negligence is on the KSRTC, driver of the KSRTC, the order dated 29th October 2022 has to be restored, and the claimant's appeal is allowed by enhancing the compensation from 5,41,897 to 3,15,977.
Please.
Accordingly, appeal.
Shetty.
Milords, and for the respondent, Milords.
They has, literally, we have, my lords, I have awarded 10,000 rupees per month, my lords. For my kids, 5,000 each has been awarded. Before the trial court, they have stated that I'm having a earning 30 lakh rupees per month. They not proved anything. They have a,
So there are two writ petitions, one by the husband, one by the wife. Who you represent whom?
Only one.
only criminal petition.
Oh, it's only WP petitioner.
Yes,
That's what
madam.
I'm asking.
Chandrasekhar K.
Yes, ma'am.
It's your writ petition, you argue.
Yes, please, madam. In page number 22, my lord, incident order, my lord. Trial court awarded 20,000 maintenance for the wife, my lord.
The respondent is directed to pay a sum of rupees 10,000 per month to petitioner number 1 and 5,000
5,000
each to petitioner number 2. That
2 and
is
3.
20,000.
My lord.
The petition deputy furnisher account details so and so. What is your income?
My income in 5,000 per month, my lord.
Huh?
5,000.
What do you do?
I am a green vegetable seller. Vegetable seller in street, my lord.
Come to the discussion part. On what basis the court had granted? Come to paragraph number 12.
Para 12, my lord, in last fourth line, my lord.
No, come from the starting.
Here in para 12, my lord. Here in the respondent has admitted that he is the working and earning, but the petition number 1 has not admitted that she is working or as source of income. The respondent has not produced any material before this court to show that through flower vending and watchman parties, though affidavit of assets and liabilities of the respondent shows that he is an uneducated and unskilled man, work, but he is regular source of income from vegetable fruits vending business. Further, the copies of proceeding of land acquisition officer Mysuru and record shows that the property of father of the respondent was acquired and sum of rupees 61,64,751 has been awarded to the family of the respondent of the compensation.
What happened to that?
This is my sisters equally shares.
But anyway, you have 12 lakhs.
So last, my lord, in the my house construction is starting, my lord. My house.
You have 12 lakhs.
So last, my lord, in the my house construction is starting, my lord. My house construction is starting. And wife, my lord, 5,000 each children.
It's what you said.
my lords, with regard to income, my lords, with regard to income, they have told they have earning 500 rupees per day. For the sake 500 rupees per day. For the sake of getting this order, they have made statement like this, my lords.
What
And
is the
then-
material you have to say that it is not correct?
Lords, they are not properly because they are earning more than 500 because I'm not there in that house to tell how much they are getting. But not 500, it is that much they can't get any income per day, my lords. And then they have told 12 lakh rupees they have a share in that awarded property, my lords. He is the only son. They are not giving any share to their sisters. He is only the son, my lords.
All these things court can't assume. There should be something before the court. That's why the court said during the course of the 1,000 and let the court go ahead with
My
the.
lords, they have a award as 1,75,000. They have received a award. 1,75,000. They have received a award, my lords, because
So you
they have
yourself
not
said
produced
65,000.
any-
65
Since I'm not
lakhs.
residing with them to produce because I'm not getting any documents to show.
Court is also not with them. So how the court will know that it is 1 crore and odd? Please come.
And
read by the
with regard to the house construction, they have showed, my lords, that
No,
is not.
Unnecessarily, instead of keeping this petition here, court proceeds with the trial. all these things you can place, court will decide. Agreed with the order passed in criminal miscellaneous number 279 of 2023, dated 19th April 2024. Both the husband is before this court, questioning the quantum of maintenance, whereby the court had granted 10,000 to the wife and 5,000 each to both the children. According to the claim, the petition is filed seeking maintenance of an amount of rupees 25,000 each to the three petitioners that is to the wife and two children, and also alternative accommodation or pay a rent of rupees 15,000. It is a case of the wife that the husband is paid a sum of rupees 61,64,751. And the husband is having enough income. It is a case of the husband that is working as a daily wage laborer and he has no other, he is not in a position to pay the said amount. Court, considering the fact that at least an amount of rupees, considering the fact that the had granted maintenance of 10,000 and 5,000 each, that is 20,000. Then counsel for the petitioner submits that he is a daily wage worker and his income is about 9,000. What you said, 9,000?
5,000. 5,000.
Not even 9,000. They stated that his income is 5,000. And land council, shall I record that it is only 12 lakhs?
What?
Record? Shall I record?
As per our trial court advocate instruction.
It is submitted that he has a sisters, whatever is the amount that is granted as the land acquisition compensation, it has to be distributed equally among the siblings, and the entire amount is not with the husband. And the court, without any basis, with the husband, and the court, without any basis, has granted exorbitant amount of 20,000 per month, which she is not in a position to pay. Then counsel appearing for the respondent wife submits that considering the financial status of the husband and the fact that he has got a lot of compensation in the land acquisition proceedings, court had rightly granted the compensation. It is repeated that only for the purpose of evading the maintenance to the wife, the husband has come up with different stance, and in fact, his family is a well-settled family, and the amount of compensation, amount of maintenance that is awarded by the tribunal is just and reasonable, and no interference is called for. Next paragraph. Having heard so and so, both the parties have taken respective stance with regard to the income of the husband. Trial court has rightly observed that all these issues have to be decided by the court during the course of trial, but not at this stage, basing on the material on record and considering the land acquisition that's granted, the compensation that the family has got. This court deems it appropriate to pass the following order. The amount of maintenance that is awarded to the wife is reduced from 10,000 to 5,000 and from 10,000 to 5,000. And for the children, this court is not interfering. Accordingly, the order is modified. The petition is disposed of.
Bill number
Yes. Next.
2, Revati, Nade for petitioner.
I appear for the respondent wife, Your Honor. The
A
petitioner.
short passover may be granted. Senior is another during the matter.
Any interim order in this?
No interim order has been.
Yes, this is matter in the month of October. Delete from Patter.
Your Honor, had heard this matter. The child is really not in safe hands, Your Honor. The husband is an alcoholic. He's a chain smoker. He also visits prostitutes.